You guys familiar with this? The good old book trust. So we're going to talk about some of the differences tonight with a book trust as well as a digital trust, the advantages to each and every one of these scenarios that can actually pan out on here. So the old-fashioned book trust doesn't protect you from a lawsuit, divorce, or a bankruptcy when you have one of these with your children. How many people in here are using beneficiaries on their house? Or TOD, the DMV told you to use a TOD for your RV, your boat, your jet ski, or how about putting your most responsible child on your bank account because you were told that was a good way to avoid probate? Anybody? Tonight, we're going to go through some reasons as to why this is not a good idea, and you will not like those beneficiary deeds after this presentation. So today, you guys, there's a few things we're going to learn about. Hopefully your note sheets are all filled up and taken care of. If I didn't help you fill those sheets up, well, I'm sorry, it wasn't very informative, but I think you will. So I'm going to challenge you guys to take some good notes here. So what we're going to learn about today: what happens if there's no legacy in place? 7 everyday situations that can lead to emotional and tragic results and how to prepare for them. How to write the ultimate love note to your family. You guys, imagine when your parents passed away and all of a sudden you got an email after they passed away with a video, them saying to you how much they loved you and cherished this time on their vacation with you, and we did this with you, your brother and sister growing. How valuable would that be to you guys? Every one of your grandkids, your children, you get to make a personalized testimonial in here that you're saving for them someday, so when your time rolls around, that they're getting that video that you left for them. Book trust, you can't do that, you guys. So it's a very personable way of leaving stuff behind for your family and that farewell to your family on the way out. Great memory for them to have. We're going to touch a little bit on how to develop a tax-free income, but we're not really here to talk too much about that, you guys. We do work with tax consultants, and we're also going to learn a little bit on how to potentially lower or eliminate taxes on your Social Security. Hands in the air here if you guys are paying taxes on Social Security. All right, 50%, 85%. Has your advisor ever told you that you could potentially not be paying tax on this Social Security? Well, 2 reasons if they didn't, you guys. 1, your advisor just didn't know. Or 2, they didn't care to tell you. Either way, you should probably give them a call tomorrow and find out. Social Security, if you look it up on Google, it's not a taxable benefit unless you are taking too much income. There's good income and there's bad income in retirement. Anybody in here know what bad income is on retirement? Any income that shows up on your tax form. Everyone's got a unique situation in here, but just because you got $1 million in your portfolio, it does not mean that you can't lower your tax liability each year. If you're not getting this tax advice from your financial advisor, 1, they just don't know. 2, they don't care to tell you. I implore you to come in and learn a little bit more about this. We'll move past that though. We're here to talk about mainly estate planning today. Anybody in here met this farmer named Jed? Well, he's got a great estate planning story, and I'm going to embellish it a little bit. So forgive me ahead of time, but this is a farmer named Jed. Hard worker, 85 years young. His wife passed away about 6 months before this picture here. He's going through all his estate stuff, and he's only got one child, and he's got this awesome house here. You could even see his service quarters over here on the right where the caretakers of the land actually live, and all this beautiful acreage out there on the property. That's Jed's farm. He's got one child, his beautiful daughter, Ellie Mae, up here. And now, while we do know that ladies are the superior of the 2 sexes, regardless of which one you are, a big farm's a lot for any one person to run. Would we all agree here? Big farm. So Jed did the same thing I did with you guys. He sent a mailer out to the most qualified people in town, inviting him to a dinner to come and attend, and they partied and they danced and had a great time. But by the end of this, Jed said to all the bachelors here, I want to let you guys know I mailed 25 of the most eligible bachelors here in town to potentially take my daughter's hand in marriage. But before we figure out who it is, Jed had all these young men line up right along the pool here, right here on the left, and he said, there's going to be 3 prizes for the first person that can make it across, and you get one of 3. 1, you get $1 million cash. 2, you get 10,000 acres of my best land. Or number 3, you could take my daughter Ellie Mae's hand in marriage. And if you take her hand in marriage, you're really going to get all the stuff, right? Because she's the only child here. So before you could even talk anymore, you heard look at that alligator in the pool though. Big snake in the pool. By the way, there's piranhas in there. He really loaded up. And before you could say anything else, splash! And this gentleman goes ripping across the pool, and he jumps out in record time in like 4.6 seconds, and Jed was just blown away. I've never seen someone swim that fast in my life. The young man gets out of the pool, and Jed says to him, well, son, you must want the $1 million cash, right? No, sir. Well, you must want the 10,000 acres of my best land then, right? No, sir. Well, welcome to the family, son. You get to take my daughter's hand in marriage. And he goes, no, sir, all due respect. I don't want to marry your daughter. And the farmer, just totally perplexed, looks at him and says, well, son, what do you want? He said, I just want to know the name of the man that pushed me into that pool. Thanks for laughing. Yeah. Well, imagine, you guys, 3 hours from now, 3 days from now, 3 weeks, potentially 3 months, or even 3 years, you guys get a call, and it's your son, your daughter, wife or a spouse, and they're in the hospital, and you show up, and you're not able to make a decision. Anybody have those old documents for like healthcare power of attorney or a finance power of attorney? Has anyone actually done one of these yet? Couple hands, good? All right, good deal. Paper in the safe, security box. Hope the kids got the code to that, because in an emergency, if you were in the hospital, they got to find that paper, and it's 2:30 in the morning, and they got their slippers on, and they're getting to the hospital and potentially can't make a decision for you in a time of need. So we're going to talk to you guys a little bit today about these Fortune 500 companies, what they're doing, how they're estate planning. We're going to talk to you a little bit about jurisdictional shopping. Does anybody in here understand what jurisdictional shopping is? Hands up for anybody? No worries. Well, 64% of Fortune 500 firms are Delaware incorporated. Anybody know why?
Tax benefits.
Tax benefits. They have some of the best tax laws. That's exactly right. Well, Microsoft, anybody know where Microsoft resides? Washington, bingo. You know where they're incorporated? Delaware. Have you guys ever heard of a little company that was actually formed in a little town called Bentonville, Arkansas? You might know the name of the store. It's Walmart. Yeah, Delaware. So all that is an example of jurisdictional shopping, you guys. Just because you live in Oregon doesn't mean you have to buy a car in Oregon. Doesn't mean your other rental properties can't be in Idaho, right? Heck, we order things online on Amazon all the time, right? I bet you guys jurisdictionally shop a few times a day. All the packages showing up to the house just means you can order outside of your state. Why is this important, you guys? Because we actually use Nevada law to go for our trust system. Nevada is the first state that has codified the entire law and legal system electronically, allowing them to automatically update all laws and you to be able to make changes from your dinner table at the house for a one-time flat fee, which is a fraction of the cost of a traditional book trust, by the way. This, you guys, is the 10th annual Domestic Asset Protection Trust State Rankings. Just one example up there. I'll actually go down here a little bit so you can see this a little better. This was the 10th annual domestic one. This is the 11th year actually right here. The last couple years, Nevada law has been ranked number 1 for the annual Domestic Asset Protection Trust, helping families avoid probate. We're going to talk about 8 reasons Nevada is actually a leading trust system, go through a few of these things. We got a beautiful family up here, you guys, and we're going to tell you a little bit about why we're here, who we are, and why we're here to help. It's a couple more things that we're going to talk about. The difference between strategies of wills, your current trust if you guys have one already. We'll touch on tax planning and strategies a little bit. We already kind of talked about the Social Security a little bit, if that's the situation that you're in. Anybody here have a written plan to divorce the IRS and put yourself in the least liable situation for taxes? Anybody got one of those written out yet? All right, well, let's talk a little more about that. Financial growth, strategies, and protection. Anybody here lost money in the stock market during retirement? I see a few sore faces after that one. Yeah, that's what happens. Well, just because you retired, it doesn't mean you actually have to lose that money. You guys, there's plans that'll give you a large portion of the upside. In worst case scenario in any year is a 0%. A lot of advisors don't talk to people about this. They're what's called AUM, assets under management. And they are paid for every dollar, every single year that you have your money in the stock market. Whether they're right or wrong, you're the one that loses and they still get paid. We won't talk too much about this. It's mainly for estate planning today, but this is part of your estate planning is the income in your guys' retirement, making sure that you have a guaranteed income plan. So 40%, you guys, of America right now has a will. Only 17% have a trust. Who in here was told that your trust avoids probate? Is your trust funded? Funded. Funding. Write this word down, you guys. We're going to learn a lot more about this. We're going to talk about funding. Funding doesn't mean you paid for your trust. Funding means that every one of your assets have been retitled in the name of the trust.
Yes, I've heard about this.
And when you go to retitle your trust, it can be very expensive, time delays, confusing, and cost quite a bit. We're going to dive into that a little bit more. So just because you have a trust, if it's not funded, it's obsolete. A partially funded trust only partially avoids probate. We're going to go into this a little bit more, you guys. A few findings, interesting facts. So nearly half of all the respondents, they did a little survey across society here, and nearly half of all respondents believe their estate planning is only for the ultra-rich, and that most people don't need it. 25% don't even want to talk about it with their families because, God forbid, you got to talk about your own death. That's not a very common conversation at the dinner table. Most people aren't a fan of that. 25% of families don't even have that conversation. 49% say their assets aren't enough to even worth considering an estate plan. Hands in the air here if we know the probate cutoff in Oregon. Anybody? $75,000. Now, you guys, it's no coincidence that all you guys are in this room today. You've all done very well. We only mail a certain demographic. So it's no coincidence that you guys are here. But there's also a problem. You've done very well. And this could be a problem for the family as well. And we're going to go into this a little bit more. 61% of people say a will is good enough to meet their estate-related needs. 35% of people know or have a loved one that has lost somebody, and they're currently going through and fighting about who's getting what in their family. Very common scenario. 46% of Americans say that they are interested in learning a little bit more about estate planning, and you guys fell into that category today, so thanks for showing up tonight and allowing me to educate you guys a little bit more on some estate planning. Now, you and your family, we're going to need an estate plan. We're going to go through a few everyday scenarios here that anyone in this room may have already experienced or could experience at any point in time in their life. So, scenario number one, we touched on this a little bit. Imagine your wife goes to the store, your son gets in a bar fight, somebody crashes into your family vehicle, and they can't make a medical or a financial decision for you, or you can't make a medical or financial decision for them. Anybody that has an IRA, 401k, 403b, checking savings, these are your assets, and they can't belong to a dead person. And if somebody can't make a decision on that because they're not a healthcare power of attorney or a finance power of attorney, your assets are on a one-way ticket to probate. Anybody in this room want to go to probate? Anyone? All right, facetious question, I know, silly one. So we're going to go through a couple different scenarios here, you guys. And oftentimes when someone needs to make a decision, they have this paperwork. It could be put away in the safe somewhere where your kids don't know how to access that safety deposit box. Or by the time they get to it, maybe it's too late to make that decision of what it is that you needed. So we're going to talk about a few more ways of how we can actually avoid this, you guys. Here's your kid. a couple daughters you got there, and they show up to the hospital. They say, who are you? Well, I'm Jerry's son over here. Okay, you got paperwork to prove that? Well, no, you just called me in an emergency and I just flew down to the hospital because you called me. Like, were they thinking about going into your safety deposit box, finding all this paperwork, driving down there? Absolutely not, you guys. This could really delay needing to make an emergency make a call in an emergency situation. This is an interactive medical ID card that each spouse will get. If there's a couple, then you each get one. If you're single, then you get one, and your beneficiaries will actually receive one of these. It actually lists all your medications on here, anything that you're allergic to. Maybe you have a DNR in place and you wouldn't want to be resuscitated, or maybe you have some kind of tolerance of what you will or won't tolerate with medical treatment. All this, you guys, is listed on this. You just keep it in your wallet or your purse somewhere safe. Your beneficiaries get one of these cards as well, and they'll keep it in their wallet or their stuff. So if this is something that really stands out to you, the interactive medical ID card. This, you guys, is included in the trust that we have to offer. The healthcare power of attorney is taken care of. The finance power of attorney is taken care of. Now, for example, was that your name over there, Sil? All right, Sid, all right. Imagine, Sid, that you need a decision made for you in a prompt amount of time, and they just got this card. Boom. Healthcare power of attorney. But maybe you would want your wife to make the financial decisions for your family. But maybe your brother-in-law is a doctor and knows a lot more than your wife does about that stuff, and you would want him to make your medical decisions. See, you guys, not all is it one person that always makes all these decisions. Someone actually passes away, your healthcare power of attorney dies, you got to call your attorney and update that. With our platform, you just sign right in and make a change. Instantaneous, you guys. Anybody in here, again, I saw a lot of hands go up when I asked if you like control. Anybody like control? Oh, is that all the hands I see? Yeah, we like control, yes. All right, you guys want to make control of your decisions. Absolutely, so do I. Would this be a concern for you? So here's another scenario number 2 here. Beautiful family over here, gentleman on the top right up here, he's got a large IRA, and his wife over here on the far right, their son in the middle with his wife and their beautiful children. And they're going to dinner one night, having a family dinner. They get in a car crash, and he's in the driver's seat, wife's in the passenger seat, son's in the back seat. They all 3 die. Now what happens? They don't know who died first. You just entered probate because they can't prove who passed away first on the scene. Now I know what a couple of you guys are thinking here. I got a few kids, that's why I had a bunch. I'm just leaving it to one of them. Well, hopefully you guys have more than one kid. Okay, sure, his share might be divided up amongst the other 2 kids. You got 3 children, one of them dies, you guys die in a car crash, and then the rest of your money and your assets is going to be divided up amongst the 2 surviving children. Is it anybody's intention in here to disinherit their grandchildren? I know people like their kids, but y'all love your grandchildren. Would you agree with me here? Now, maybe your advisors, anybody heard of per stirpes or per capita, any of this stuff? You guys, not most people are using those on their accounts. They're using beneficiary deeds, or you just got your wife or your spouse as a primary beneficiary, and then you got your children as contingent beneficiaries on there. We're going to go a few more reasons of how this could be a problem, because in this scenario here, they would have unintentionally disinherited their grandchildren. His share wouldn't have automatically gone to his children. It would have gone to the other 2 surviving kids in this example, and you'd be counting on their integrity and honesty to give those children their share. We already read the last side. 35% of families are already fighting over something like that, and it's not actually happening the way it's supposed to go. With a proper estate plan, you guys can actually avoid this. Scenario number 3, joint tenancy. Anybody here got their house paid off? Anyone? Congratulations. How about close? Anyone got their kids on that beneficiary deed or on the house? Anybody got their kid on the house? Yeah. You got them on there as a TOD for the beneficiary deed on there? Okay. Well, some people even put their kids on the title of the house. Well, imagine this scenario here, you guys, where they have a joint tenancy situation. All of a sudden, your daughter's on the house, or she's even on your bank account. And then your son-in-law decides to divorce your daughter, or vice versa. And they hire an attorney and they go into divorce court. And the attorney does a skip trace and finds out that your kid is on your bank account or on your house, and you just paid your house off. And you're having to go down to the bank and give up half of your money out of your account and take a loan out on your paid off house to pay off your ex-son-in-law that just broke your daughter's heart, by the way. And you go down to the bank and you're taking out a $250,000 loan here on your $500,000 paid off house, free and clear here. And they ask you, hey, Joanne, are you guys putting in a new pool? You taking them on vacation, Sid? What are you doing with the money? No, I'm here to pay off my ex-son-in-law that just broke my daughter's heart. Could you imagine finding yourselves in that situation? So there's a few reasons why you go to the bank here, you go to your mortgage company, your lender, and they tell you joint tenancy. Don't do it. This could potentially put your family in probate. Just put them on the house or the bank here. And we just saw here, he decided to divorce the daughter and take half these assets because it was considered marital property. We're going to talk about another scenario here, an unforeseen event, like a lawsuit. Well, imagine here for a minute, you got your daughter on your bank account, your son on your house, it's paid off, and they're law-abiding citizens, they got their car insurance, they're in a vehicle going down the road, and they hit some black ice on the road, and they get out of control, and whap! Kill a family of 3, and there's a survivor in the car. This happens. And she calls her insurance company, and she's got the minimum amount of car insurance. She's got $300,000 of bodily injury on there, and she just killed 3 babies in the car. And now she's getting sued for $1 million. She don't have it in her account, but she's a joint tenant on your bank, or they got a joint tenancy on the house there. What do you think they're coming after next?
Everything you own.
Everything you own, Lee. That's correct. So another reason, anybody like those beneficiary deeds now? Anybody like those joint tenancies? I know, I got some facetious questions today, you guys, but I got to arise some curiosity and understanding here and convey this to you because this happens every day. 230 probate cases open up in each state each day, and over $150,000 a day on average in each state goes in probate fees alone. That's $2 billion a year. You guys, probate's a choice. It doesn't have to happen. Lack of education and procrastination are the only 2 things that'll wind you guys up in probate. Sid, you look like you're worth about $10 million. You know how long it would take us to get your trust funded and protected? 1 hour. 1 hour, 1 hour, 1 hour, 1 hour, 1 hour. Every person, after with all your stuff in hand, all your assets, accounts, house, all your titles, could have your trust funded in 1 hour and eliminate every one of these situations that could potentially arise if you guys were to find yourselves in this scenario here. Thank God it didn't make me restart again, huh? There we go. All right. How about a bankruptcy? Anybody in here see COVID coming? Who saw that one coming? Or was that a total surprise, man?
Oh, no, not surprised.
You got the weatherman here, all right.
Not surprised by it.
Well, you guys, imagine this. One of your children started up a business, a construction company, or a flower shop in 2016. And they're trying to get their business up off the ground and get things scooting along, and COVID comes along. Who could receive a flower during COVID? No one. Couldn't send them to people's doors, couldn't send them to the hospitals. And then your child's business goes bankrupt. And they file bankruptcy. Unconsciously, they're the joint tenant on your house. They got a joint bank account with them. We could have a car crash here, all these different scenarios, and their child experiences bankruptcy. Whose assets are they coming after now?
Everybody that's available.
Everybody that is sharing an account or a house. You guys, the beneficiary deeds don't protect you from a lawsuit, a bankruptcy, or a divorce. These are 3 things that you are not safe from by sharing this stuff with your children. There are ways around this. Would this be a concern for any of you?
Absolutely.
All right, here's another scenario here, a very common everyday scenario. So mom here, she's got a fairly large IRA. Her daughter here, she's a banker, making $50,000 a year. And her mom passes away, and she inherits the IRA. By the way, did anybody know in here that 78% of inheritances are squandered within 18 months? Even lottery winners. Yeah, so 18 months, 78% are actually squandered on here. And you know, we've actually found that if you go and ask your children, especially, you know, little Timmy or someone like that, hey, little Timmy, I'm going to give you a choice here. Would you rather take this $200,000 up front? Or you want to take this $200,000 over the course of 10 years? What do you think little Timmy's going to say?
Give me 200 grand.
Give me the money. That's what little Timmy's going to say. You know, I just lost my mom, just lost my dad, but they want the money. Is it anybody's here intention to have your child paying the most possible taxes? Well, this scenario rolls along here. Mom had a $200,000 IRA. She made her $50,000 at the bank that year, and she just went up into the 32% tax bracket, paying $64,000, only getting $136,000 for that year. She brought home $250,000, her $50,000 at the bank, $200,000 from mom's IRA here, and poof, went up. So imagine your daughter's experiencing a bankruptcy when this is going on, and you just pass away. Now what's going to happen to that inheritance there? Because she decided to take it all at once? She thought she was going to get the money? Now what happened to the IRA that, by the way, you didn't build that IRA overnight. You worked very hard. You contributed for 30, 40, 50 years. It took you a long time to build this money up and this pile up. Should this whole pile of money be able to poof, disappear overnight? It really shouldn't. You may want to consider an estate plan. You guys, if any of this stuff is important to you or really sticking out, please write it down on the sheet there. We implore you to come in and take advantage of the 1-hour consultation that you guys will get with us. Don't let Rachel let you out the door without getting this appointment sticker on the way out. She'll give you directions to our office, our cards, and an appointment time for you guys to grab on the way out. Next scenario here. Did you guys ever think about your IRA potentially causing a divorce? Well, imagine this. You got $500,000 in your IRA, Mindy, and all of a sudden, you pass away and your daughter wants to take all the money all at once here. And she says, you know what, I'll just pay the tax on it. I'll just get rid of it all at once. So she gets $500,000 pre-tax. She pays the most possible tax on there, and she gets like $300,000 maybe and some change afterwards. And then it goes into their joint account. That's the perfect time for your son-in-law to go and apply for a divorce. Because that money just went into there. And a lot of you guys, your children's marriages are iffy. And you don't even know it. What they're fighting about behind closed doors, whether it's finance or infidelity or work or whatever is going on, they don't always tell you guys about this kind of stuff. And this would be the perfect time for your daughter-in-law or your son-in-law to go and ask for a divorce because it's considered marital property. Anybody potentially want to squander their retirement or see their kids just poof, lose everything because of divorce, of a bad decision they made? Hope not. Yeah, and there he is. The last scenario. She paid the most possible tax, went into a joint bank account. Now he's going to a divorce, and now she's left with $68,000 instead of the $136,000, even after paying the most possible tax and taking the money all at once. All right, anybody in here heard of an IRA beneficiary trust? Uh-oh. Who in here has a financial advisor? Hands in the air, please. Financial advisor? There's only 2 reasons your advisor is not telling you about an IRA beneficiary trust. One is they don't know. The second is they don't care to tell you. Now, Jerry, would you like to know today, or you want to hear in 5 or 10 years from now?
Right now.
Fair enough. Anybody? Either way, if they don't know, I implore you to come in and take advantage of this consultation. We can tell you about this. And if they don't care to tell you, you should probably come in and see us and we'll educate you a little more on this. You guys, an IRA beneficiary trust is going to protect your children from a number of scenarios. It's going to help manage the distribution after you're gone. It's going to protect your children against a lawsuit, a divorce, or even themselves. Let's use an example here. That always stories actually tell here, right? You got 3 children. I'm going to say David, Hannah, and Orion here, all right? Orion has got his stuff together. He's smart. Maybe you want him to get his share of the $300,000 you're leaving him in one chunk or over the course of 3 years. Maybe Sarah here's got kind of an iffy marriage or business isn't doing so good. Maybe you want her to get her share over 7 years. Maybe your son, David, or someone has a gambling problem, and you want him to get his share over 10 years. You guys, not every one of your children's scenarios are the same. There could be a big difference, and you can manage that distribution with this. If your advisor is not telling you about this, again, they don't know or they don't care to tell you. Either way, you should probably come in and take advantage of this consultation. We can tell you about this. This is built into the trust that we work with at no additional cost. Scenario number 5 here. Anybody heard of conservatorship? Conservatorship, regardless if you've been married for 50 or 60 years, if you don't have a healthcare power of attorney, you can't go in and make a decision for that person until they pass away, because you have to die to inherit the money unless you have a healthcare power of attorney. Now, there was a story. It was actually one of Scott's clients. And this couple came in. They had been married for like 62 years, and she gave him a call one day and, hey, Scott, marry who? You know, we sit with a lot of people, like trying to remember every name in the room is quite a task, right? Let alone doing this regularly. She says, you know, the ones that were in their 80s, we've been married for 62 years. He goes, oh yeah, what's going on? How can I help you? Well, her husband took a trip to Walmart, said he'd be back in about an hour. 3 hours later, Walmart is saying, hey, Miss Smith, is Bob Smith here your husband? Yeah. Well, he lost capacity here in Walmart and he doesn't know where he's at. We need you to come down here and get him. So she goes down and gets him and comes back and, you know, calls Scott and lets him know what's going on and say, hey, we need to talk to an attorney and not take care of this healthcare power of attorney. Well, you guys, he was incapacitated. They couldn't get this document taken care of. You just entered living probate now. And what had to happen was they had to appoint a court-appointed litem. Because when she went to court, the judge asked her a number of questions, and the judge determined that based on her age, the medications that she was taking, and how she answered the questions, that she was not fit to make financial or healthcare decisions for her husband, who she'd been married to for 62 years. Because they didn't have a healthcare power of attorney. Would this be a concern for any of you guys? Big concern. It cost her $8,000 to get this court-appointed litem, and they had to pay a monthly fee. And by the way, how would she have to feel for a stranger making decisions for her husband who doesn't know him from Adam? That would not be a good situation to be in. So conservatorship is not a good situation. You need to have a healthcare and a finance power of attorney. Now, if your spouse is in this coma and becomes incapacitated, we touched on this a little bit already, but your spouse has this IRA. Maybe that IRA, the individual retirement account, is the sole source of your guys' money, and there's some big decisions that need to be made. And potentially, you can't make a decision because you don't have a healthcare power of attorney. Same for your children, you guys. Your children need to come and see us. If you guys have adult children over the age of 18 years old, we invite them to come in and see us. It works the same way for them. If you don't have a healthcare power of attorney and you're not a healthcare power of attorney for your children or a finance power of attorney for your children, you cannot make decisions for them as long as they are incapacitated. Again, these documents come with this. When you get it taken care of, you get one. And if your children need this set up for them, we can talk about that as well. So proper estate planning can address all of these scenarios, you guys. Every single one of them. What's better, a will or a trust? In some cases, yeah, well, with this you get both, because a will is saying what you want done with your assets inside of the trust, and if a trust, well, If it's not funded, it's not done properly, or you're using beneficiaries, TODs for your hard assets, beneficiary deeds on your accounts, or PODs on your savings accounts, it could still go into probate. So what is the probate court? Got the definition up here. Granting of probate is the first step in the legal process of administering a deceased person's estate. It resolves all claims while distributing all the deceased person's property under a will. So a will must be probated. Anybody familiar with how long it takes for the probate process here in the state of Oregon? On average, 6 to 9 months. However, if you got a complex situation, multiple kids, people fighting over things, people contesting your estate, it could potentially take longer, much longer. Here's an example. You got this nice house and you've done some remodeling on there and you just got a nice rock driveway laid down here and everything all cleaned up, and the landscapers just came in and gave you a quote on $10,000 to get all this rock done on all your driveway here, and they say, hey, we need a $5,000 advance, Jerry, on the job here for us to go get the rock and the material and lay everything out here. They start the job and you go home and you die in a car crash on the way home. They actually have to alert the newspaper 3 times. It has to go in the newspaper 3 times that you passed away for anybody that you could have potentially owed money, like this landscaper coming back to sue your family for the other $5,000 they owe them. Well, you should pay them. It's the right thing to do, right? But imagine how many people could be contesting your estate and slowing down the probate process as though 6 or 9 months isn't long enough already. Probate's a choice, you guys. Here's the problem with probate. Number 1, fees. The threshold in Oregon is $75,000. Now, because I know every one of you guys just a little bit, because we strategically mail everybody in here, every person in this room has over $75,000 worth of assets between your car, your house, accounts, everything like that. We only mail to a certain demographic. If you got over $75,000 and you don't have a trust in place that is funded properly, one-way ticket to probate. 6 to 9 months. Costs between $2,000 to $100,000. It really depends on the level of your assets and the complexity of your situation, as well as the number of people protesting your estate and what it is that you're leaving behind. I mean, you guys had to toss a quarter here. You probably don't want to toss a quarter over this, but would you rather your assets go to the state of Oregon or your family over here? $153,000 a day, you guys, in each state. 230 probate cases every day in each state. Over $2 billion a year is going into probate, and this could be avoided entirely. Heck, shouldn't they be teaching this in high school?
Oh, no.
God, I went for 7 years and I didn't hear it once.
Don't want to inform
Nah,
them.
just
Why would
kidding,
you do
6
that?
years, no.
They don't teach civics there anymore.
Yeah, no, they don't. Well, all right, delays. What could happen up here? Who's going to pay that mortgage of yours for the next 6 to 9 months? Who's going to pay the utilities, gas, water, electric, sewer, car payment? You know who? It's going to be your most well-off child. They're going to have to step up. And then they're going to be fighting the next 20 or 30 Christmases because they had to fork all this money over for your estate while it's in probate. You can't access your house when it's in probate. They can't touch any of this. What happens if you don't pay the bills? Well, it's going to get foreclosed on. Then what?
You lose everything.
Then you're subject to some lowball investor coming along having to buy the house for way less than it's worth. Like, this could be avoided, you guys. You don't have to go through this. Your children don't have to go through this. It's the hardest time in someone's life when they lose their mom or their dad. Is it anyone's intention in this room to impose an additional financial or emotional burden on their children after they pass away? I'm glad I don't see any hands. Public record, you guys, as said, your probate estate must be listed in the newspaper 3 times. Contestability here, exposing your probate estate to the public, can lead to this. What's a will equal? Anybody want to give me a guess?
Probate.
Bingo, Mindy, nice one. I'm taking you to bingo. And trivia, you were killing it earlier. All right, will equals probate. This is what has to happen in the probate process. There has to be a process. They're taking your family property, your house, your boat, your jet skis, your RVs, all your hard assets next to your liquidable assets, such as cash, stocks, bonds, securities, 403Bs. All this, it's got to go into this proverbial box here, and it has to be inventoried so the court can decide who is getting what. Now, generally speaking, everybody in here, I'm sure, within a $5,000 or $10,000 ballpark could guess their net worth. Take about 10% of that, and that's what's going to go to probate. The next unfortunate thing that we've realized is because of how assets are distributed and how people choose to take their money, they're paying an additional 30% in taxes, federal estate tax, state taxes, income taxes. Is it anybody's intention in this room to have your children pay the most tax possible and fees possible? Anyone? No, didn't think so. The average family, you guys, after probate, it's only receiving about 60% of what it is that you're leaving after Uncle Sam comes in and puts his hand in the pot. The state, the feds, income tax, and probate fees. They usually get about 60%. That's a huge hit. With a revocable living trust, you guys, this could potentially pass on 100% to your children. Not every time, but there are scenarios where you could pass on 100% to them. With the right estate plan in place, you guys, you can make sure that you're leaving your stuff in an efficient manner, that they can access it quickly. You're eliminating the costs, or severely, or some cases entirely eliminating the cost of the tax on how they're inheriting your assets with the right estate plan in place. A few fun facts, you guys, a little more celebrity trivia here. Elvis Presley had a $10 million estate. $7.3 million went to probate and other costs. Crazy. That's 73% of his money. Howard Hughes had a $2.5 billion estate. He was one of the richest men at that point in time in the world. 100 people filed claims against his estate. 100. 7 years to settle. Proceeds went to 22 cousins. Michael Jackson, $1 billion estate, 3 kids, 2 ex-wives. Mothers went to probate, 7 years to settle. Interesting fact, Abe Lincoln, he was like an estate, he was a lawyer as well. He didn't even have an estate plan. Left nothing behind. Dr. King, no will, no trust. His kids have been fighting for 46 years. They still haven't settled Dr. King's estate. Could you imagine? There's that many people contesting it and protesting it and everything, that 46 years they've been fighting over his estate. You guys think Prince knew he was going to die in an elevator at 57 years young? You think Michael Jackson knew he was going to die, or Elvis knew he was going to die on the toilet at 42 years young? Prince here, you guys, was 57 years young, died in an elevator. He was worth over $300 million. And his family didn't even have enough money to bury him because his stuff went into probate. Could you imagine your kids not being able to bury you because your stuff went into probate? As a matter of fact, George Lopez stepped up, kind guy, grace of God, came along and gifted his family $20,000 so they could bury him. Could you imagine? None of them saw this coming. They thought they had plenty of time left. All right, back to probate. So probate's not the problem, you guys. Probate does serve an important purpose. People's assets do got to be distributed that don't have a plan. But after today, what's this, my alarm? Oh, it's my life alert button, excuse me. No, I'm just kidding. That's my 10-minute alarm saying we're going to be out of here in less than 10 minutes. Otherwise, you guys will get real mad at me. So I'm going to make sure we're wrapping this up, all right? So probate is not the problem, you guys. Probate serves a very important purpose. Probate is a choice, though. Now, you guys all came here today, and you may not like my purple tie or my silly glasses or maybe my voice or something, and you might leave here and you want to go home and just think about it. Pray about it, talk to the dog about it, however you guys make a decision. This isn't like buying tires at Costco for the vehicle, you guys. This is very important. But there's only 2 reasons. Lack of education, which we solved today, and procrastination. Don't be a procrastinator, you guys. Don't put this off. This is not something that you want to put off. So, anybody in here want to avoid probate? I hope I see a lot more hands today. Oh, come on now. All right, yeah. Some people want to see the show looking down or up, depending on where you go, and watch those kids fight over it, but not me, not me. All right, this is just how the concept of a trust works, you guys. There's the grantor, the settlor, which is you and your spouse here. Assets get retitled. They go into the name of the trust. And then your beneficiaries, whether it be your children, brothers, whoever your beneficiaries are, will receive that, being beneficiaries inside of the trust. If you already have a trust, are you guys 100% sure your trust is funded? If not, you should probably book an appointment with us and come in and find out. Second, is your healthcare power of attorney HIPAA compliant? Laws change. You guys, if it's not HIPAA compliant and you can't even go in there and you got a healthcare power of attorney and you find yourself not being able to make a financial decision or a healthcare related decision because your HCPOA, healthcare power of attorney, wasn't up to date or HIPAA compliant, you could potentially enter living probate. 3, does your current trust have an IRA beneficiary in there? Do you guys have a wealth plan on how you're passing this on to each one of your kids? Maybe it's not an equal amount at an equal time. This is really important, you guys. Again, there's only 2 reasons your current advisor or whoever's helping you with your finances have not told you this. They just don't know Terry or Joanne. They just didn't care to tell you. Whichever it is, we implore you to come in and see us. We can fix this problem for you guys at the fraction of a cost of a book trust. Number 4, are you sure who your successor trustees are, successor executors, healthcare and financial power of attorneys are? Do you have a pour-over will? Have you had any major family changes like divorce, marriage, births, disability of a family member, inheritance, major purchases of other properties or other assets? If any one of these things have happened since the last time you updated your trust, you only have a partially funded trust. Anybody want to spend $1,000, $2,000, wait another month or 2 for the attorney to update this? Or you just want to sign right in on your computer and make that change right now? Not have to worry about it. Bam, done. And 7, have you had any arrangements as to how? Of course, messing with me here, yep. All right, have you had any arrangement as to how you'd like to be treated or not be treated? If you were to become incapacitated, me personally, if I turn into a vegetable, pull the plug, please. And maybe not everybody would, some people want to carry on, some don't. Maybe you get cancer, or you're incapacitated, and you don't want to go through chemo. Whatever it is, there's so many situations, you guys, of what you would want or would not want. And if you don't have the proper documents in place, your wishes may not be executed. Would this be a problem for anybody in here? Well, you guys, I appreciate you allowing me to share some basic education on this. Again, my name's David Hadley. Don't walk out that door without dropping that paper off with Rachel over there. She will give you a sticky note as to a time and date. You guys can come by my office, my 1175 East Main Street. It's on the paperwork over there. You don't have to remember that. I'm right here in the middle of Oregon. You can even book a virtual consultation with me if you don't want to sit within 6 feet of me. I understand. I do put deodorant on though, so we're all right. Drop those sheets off back there, you guys. Thank you for coming in tonight. Appreciate each and every one of you.